it is 5 minutes to 1 o'clock. That's just how these things are. Today, the presentations were slightly longer, and I would really request that everyone just sit back, enjoy your laptop space, and listen to the last presenter. The last presenter is also no stranger to the conference. Dr. Lee Swales, an admitted attorney. He's with the University of KwaZulu-Natal. He consults for a law firm as well, and he has also taken various stints at training judges at the institute that trains judges in our country on issues pertaining to cyber criminality, e-commerce, as well as cyber criminality, e-commerce, as well as aspects of defamation. Dr. Swales will be giving the presentation today on defamation online. And yeah, I think it will be a nice presentation before you get something to eat, so that you know what people are saying about you and what you can do against those who are not saying nice things about you. Dr. Swales, can I give over to you?
Yes, thanks, and thank you for that introduction. And it's going to be a hard act to follow. An interesting presentation. So, welcome everyone. I know we've probably all got a bit of Zoom fatigue at this time of the year, and we're all looking forward to a break. But hang in there, we're almost there. So yeah, I'm going to be focusing my presentation today on, as Prof. Snail tells us, their freedom of expression, online defamation, and issues pertaining to that. Look, I think it's a particularly interesting topic given the political climate in the country at the moment, with certain allegations of incitement to cause violence, issues of defamation involving our former state president, various cabinet ministers, various political parties and others that are prominent in society, as well as potentially scandalizing the court. So there's a lot of interesting and sometimes difficult issues at play here. I think just to try contextualize this, really looking at I like this quote from Warren Buffett, who's one of the richest guys in the world and a renowned investor. And I would even go so far as to amend this to say that in the internet age, it really takes 5 seconds. So it takes 20 years to build a reputation, and 5 seconds, or as Warren Buffett says there, 5 minutes to ruin it. If you think about that, you'll do things differently. So yeah, I think if we understand how the internet works and its instant nature, and the fact that often we can say things in the heat of the moment, when we're angry, when we're drunk, when we are emotional, worst case scenario, a combination of all of those. So it can affect us personally, professionally, particularly given the way that all of us are using technology in our daily lives. You've got kids that have been probably, if you've got children, they've probably used it for school. Business models have transformed over the last decade or so. Technology's become more cost effective. Social media particularly is no longer this niche sort of teenager, young adult realm. It's something that I think has become more mainstream, far more mainstream, particularly given that we've got to a point now where the latest statistics are telling us that more than half the world uses social media, which is really phenomenal. Our courts have started to grapple with this more so in the last decade. The law generally takes a while to catch up, of course, to what's happening in society. It's no different here than anywhere else in the world. And in some recent cases, I've just given you 2 quotes there, really, where we've had our courts starting to look at it and say that the way that technology is developing, it's revolutionized the way that we communicate, the way that courts are practicing. If you're an attorney in the Cape or Johannesburg, Gauteng, you're going to be starting to use online systems. I was involved in a pilot project a couple of years back for electronic signatures for attorneys. You have situations now where both business, personal use, technology's just become an everyday part of our life. And looking at some stats before I dive into the sort of law on this, and I'll try to keep it light. Obviously, we've only got around 20 minutes. So I'm just going to give high-level overviews, really, and welcome to engage afterwards or following this on chat to me via email or on another method if you want to engage further. But looking at these stats from 4 years ago, we had around just below 50%, and I know earlier speakers looked at these stats, so I won't dwell on it. But when, if you look back to sort of mid-2000s, just about the time that I graduated from university, only around 5% of the population had access to the internet. So we've seen an enormous increase in penetration rates, particularly in South Africa and in African countries. More recently now, we're looking around mid-50s, and there's, projected to take us above the 60s in the next few years. So we've got enormous penetration rates. It's particularly with our socioeconomic conditions that's mobile, but it's still, I think, the inference we must draw there, more and more of us are engaging online, which is going to be more and more disputes are going to happen online. Those stats are a little dated, but you can again see an uptake in social media growth. And more recently, looking at this, the sort of big new climber there is TikTok. But that aside, we're seeing a large majority of us engaging on social media. I think almost all of us will have WhatsApp groups. We probably have all watched YouTube videos, and we probably all use some form of social media, whether regularly or infrequently. It's out there. And South Africans in general, again, these stats are a bit dated, but most people are spending around 3 hours online. So look, from an employer's perspective, you maybe want to try harness this, and instead of looking at it as a bad thing, looking at it to try sort of engage employees in a sort of business orientated approach. But I guess that's a discussion for another time and another day, particularly looking at COVID. And I mean, given the fact that now I'm engaging in a conference online, I've got a seminar with some of my master's students this afternoon. I'm unfortunately not going to be able to join some of the later sessions, but that's going to happen online. I had one last night online. I've been teaching for months online. We've probably been engaging via work. I've had at the university had staff meetings online. I'm sure all of us have experience of this over the last few months. And South Africa in particular, we've got a big uptake in using video conference technology. So why have I bombarded you with all of these stats, other than to try to give you something to look at that's interesting? I think what the inference I'm trying to draw here is that we're going to see increasing, we have seen particularly in the case law, far more and more cases that are going to arise as a result of disputes online or defamation. And society's evolving. It's fueling economic growth. We're communicating differently. 20 years ago, it's difficult to have foreseen this. And where do we go next? I guess is the question. But again, let's look particularly at my presentation. I'm looking at freedom of expression and defamation and those related aspects. So what underpins all of this is the section 16 of our Constitution, which is the right to freedom of expression. So the first thing you'll note there, and for those that have read this and looked at this in detail before, I'm sure most of us have, so I won't dwell on this for too long. And we use the term expression rather than speech. It's linguistically wider. And it's a jealously protected and guarded right in our country, given our history. And it also should be noted right at the top that it's not absolute, and there's no hierarchy of rights. So that on a case-by-case basis, often we're weighing up certain rights. Typically, we're going to be weighing up freedom of expression with dignity and potentially privacy. But interestingly, or importantly rather, we'll see that freedom of expression does not extend to hate speech. So I see that sometimes we say that the Constitution regulates hate speech, and I don't think technically or strictly speaking that's correct. What it does is it doesn't provide hate speech with protection. Rather, the legislation that animates this right regulates specifically hate speech. But I guess that's a sort of technical academic nicety. But effectively what we're given with this section is that it gives us the right to receive or impart ideas, freedom of artistic creativity, academic freedom, freedom of scientific research. And then we've got a plethora of constitutional court cases interpreting this right. We've got a rich history of jurisprudence here. And amongst many other cases that I could have pointed you to, I like this quote because it's important. I think accurate, and that freedom of expression lies at the very heart of a democracy, and it's critical for its functioning. So why would we say that the right to freedom of expression is important, critical really, for the proper functioning of a democracy? These are rationales that I've pulled from our constitutional court case law. The role for the right in the search for truth, self-fulfillment, autonomy, holding government accountable. There's a variety of reasons. It's a critical right, but it's not absolute. So how then does it translate to the digital world? We're all publishers. We've probably all got a smartphone, something like that, where in the instant I can publish to, even if I've got a small following, millions of people. It can go viral within hours. In the past, that kind of power of publishing was limited to newspapers, magazines. The power of publishing to such wide audiences was limited. So that's what technology has given us, is the fact that we can all be publishers of any content without having the benefit of an editor, hindsight, objective and critical thoughts, maybe even information at times. So, you know, we've got a lot of misinformation and propaganda floating out there, which is obviously quite problematic. But what that, amongst many other things, what the internet has given us is the ability to publish and publish widely. So looking at that, and specifically my topic that I was asked to talk about, and I must just say that I have written a chapter with Sizwe that's going to be coming out soon on this. So we've managed to engage collectively on this for quite some time, and have tried to, in this presentation, simplify it. But to the extent that anyone may be interested in sort of the depth of case law and other, please feel free. My email address is at the end to engage me. I'm happy to share those cases with you. I obviously can't refer to all of that detail in the short time we have available, but I've spent some months with Sizwe as well reading through all of this, and there's a lot of recent and very interesting cases here. But anyway, let's have a look at some of them and some definitions. So what is defamation? It's a delect. In the US and the UK, that's called a tort, and we don't refer to it as slander or libel. We don't distinguish. We refer to it as defamation, and it's a delect which involves an infringement of personality rights, effectively the rights of reputation, good name, and it's defined as the unlawful and intentional publication of defamatory matter concerning another which causes reputational impairment. In the recent case of our former state president Jacob Zuma and cabinet minister Hanekom, defamation was defined as the wrongful and intentional publication of defamatory words or conduct pertaining to a claimant, and having 4 requirements: A, wrongfulness; B, intention; C, publication; and D, defamatory words or conduct. In other cases, I've seen that expressed as a 5-step. It's either 4 or 5. It's the same requirements, just sometimes broken into 4, sometimes into 5. But effectively what we're looking at is a wrongful and intentional publication of some defamatory content that refers to the plaintiff. So how do we know if something's defamatory? What determines that? Well, it's an objective, reasonable person test that, in the opinion of this so-called fictitious reasonable person with normal intelligence and development, so it's not someone who holds 4 degrees in law, and it's not someone with abnormal or any other different intelligence. It's a normal, reasonable person, and we look at the statement in that kind of context. What are some examples? In LaRue versus Day, that's the latest case involving our constitutional court. Quite controversial. Professor De Vos at UCT has delivered a scathing South African Law Journal article on it, probably rightly so, because in this case we had school children who thought it would be funny to superimpose their teacher's head onto a sexual act involving 2 men. And then that went around WhatsApp, and then it got spread widely, eventually finding its way to the school notice board. And ultimately, it went all the way to the Constitutional Court, where the inference was that homosexual sex was somehow immoral. And yeah, that again is a debate for another sort of session in itself, but particularly in a modern democracy. But I think the key element here, the key point here really is that case illustrates and gives almost a history, as many good constitutional court judgments do, to the development of defamation law, the requirements, the various rationales, give some examples, for example, being dishonest, immoral, otherwise lacking honor. So it's a nice starting point if you're jumping into this fresh. But look, there's no closed list. It depends on what's going to be said, and whether it's going to make someone appear ridiculous, absurd, foolish, low morals. There's a wide variety of things that can be defamatory. But remember, it's not, the freedom of expression is not absolute. So there's often this misconception, particularly because in America there is freedom of expression is a preeminent right. It's not. In South Africa, it's ranked equally. There's no hierarchy. So we have this often misconception that I can just say what I like, particularly if I'm on social media, angry, I'm a bit, maybe I've had a glass of red wine and I just type and say what I like. And that, there are consequences. We see often politicians saying things that, quite frankly, if anyone else said, there would be consequences. And we're starting to see more and more cases come about. So yeah, freedom of expression is definitely not absolute. Here's an example. I've tried to just scratch out some objectionable words there that might make me blush. But in that case involving politicians and others, again, just an example of what could be defamatory, calling someone a lame, horny donkey, alleging in a WhatsApp group that they're going to, do certain things. So it's a variety of conduct, spoken word, online, particularly in WhatsApp groups. We're seeing more and more of this. There's a variety of cases that give effect to it, or that explain it. So what does defamation do? What are we trying to attempt here? Well, we're balancing two critical rights that are clashing. And that's a person's right to a good name on the one hand, an unimpaired reputation. And then the other is person's right to freedom of expression. And if you picture a blind lady justice, that's effectively what is being balanced in this situation. And our court, in one of the seminal cases, Kamala versus Holomisa, said that defamation lies at the intersection of freedom of speech and the protection of reputation or good name. So that's exactly what we're looking at. Recently, in a case involving also a former finance minister, Trevor Manuel, and the economic freedom fighters who are often litigants in these sorts of matters, I like this quote as well because it, I think, captures the essence of what we're talking about, and that is that freedom of expression is a fundamental freedom protected by Section 16(2) of the Constitution, and human dignity, as stated in Section 1 of the Constitution, is a founding value. The challenge for our courts is to strike this appropriate balance. So if you've been defamed, or if you're representing a client that's defamed, what do you need to show? Publication, normally easy to prove. Screenshot, got it. Which is defamatory. Objective, you can either determine that or not. That's normally pretty easy to show. And then which refers to the plaintiff, and then the onus is going to shift to the other side to show that statement wasn't unlawful. In other words, that they had a defense. So generally, acting for a plaintiff, it's pretty straightforward to make those allegations and have proof for that. But remember, we don't need to show, it's not a requirement in our law to show that the statement is false. And we don't have slander or libel. We call it defamation. Now, if I'm representing a defendant, what grounds of justification are available? Now, remember, the fact that I've got a ground of justification doesn't mean someone can't sue me. I can still be sued. I might still be dragged all the way to court, particularly by someone with conviction and deep pockets. Generally, what we see as the common defense is truth and the public interest. Remember, it's not what the public finds interesting, but it's what's in the public's interest. Very different things. That comes from taking that from the English case involving the former supermodel Naomi Campbell, who had a cocaine problem with the paparazzi there following her. And it's what's in the public's, what's truth for the public benefit, or truth, public interest. So you might look at a politician in South Africa, for example, who has 4 girlfriends. Is it in the public interest to publish that? Maybe not. Maybe that doesn't affect the way that he or she does his or her job. Potentially that would depend on the context, on the situation. Or someone a drug habit, is that in the public interest? Again, it would very much depend on the context. We have fair comment, which the comment must be fair, it must be objective, it can be critical, it can be very critical, but it must be fair and based on fact. there's a media defense, a reasonable publication, which was introduced with National Media Limited and Bagoshi in the 90s. And then privilege, which is like, for example, if you're in Parliament, or privileged occasion. So those are the main defenses that we would look at if you're defending a person accused of this. I think importantly, and I know we are short of time, there's just so much I could talk to you guys for hours about this, but I know we don't have that sort of time. So without wanting to feel like I'm rushing through this, some important points to note here. If you are sharing something online, retweeting it, posting it, forwarding it, sharing it, you are publishing it. It is no defense to say, I wasn't the original publisher. That was set out by the Supreme Court of Appeal recently in Sedu versus Lakota, where a newspaper posted or wrote some, published some unsavory allegations about a particular politician at the time. And the court categorically confirmed that it's no defense to say that I didn't say it, I'm just forwarding it. So if you are retweeting, forwarding, you are publishing that defamatory content. Interesting case involving a British politician, Lord McAlpine, who was accused of being a paedophile. That was by a presenter of a morning breakfast show. That was retweeted by hundreds of people. And that politician vigorously pursued each one of those persons, holding them liable for retweeting and sharing that defamatory post, and ironically donating all the money to a children's trust. The other interesting one with social media in this age is, what if I'm tagged in defamatory content, or I like or share it? So again, the sharing comes back to the last point, but what if I'm tagged in it and I don't do anything? Then I am associating myself with that defamatory content. And I need to take steps to disassociate myself, actively disassociate myself. Again, it won't be a defense to say, oh, I didn't know, because in most social media platforms, and I've unfortunately had experience of this and having to go to court and show and prove this, and you can prove this via, for example, there's activity timelines which can show definitively when a user logged in, what they did on that platform, and that would then show that they've logged in, they've received a notification, and then the reasonable user then ought to, for example, if you've been tagged in defamatory content, untag yourself, remove it, take steps to somehow disavow yourself from that, and don't just sit back and sort of say, I didn't know. And again, case by case, depending on the facts, but you got to take steps to disassociate yourself. That principle has been confirmed a few times. The first one there dealing with that is Sparta versus Richter. The other interesting one is, what about WhatsApp groups? Most of us are on WhatsApp groups. You know, can you have some pretty agricultural language and memes and things shared on there? What happens if you don't do anything and you are the administrator, you're the admin? Again, you're going to be sucked into being associated with that content and that conduct. So the key message here is you've got to take steps to disassociate yourself from that type of content. And again, the same applies on a Facebook group or any kind of social media group. We've had a few cases that have now sort of confirmed this position, that you've got to take these steps, and there's some interesting cases there. Yeah, what about an employment context? Can you be fired? Yes. Can you be fired for something that you say outside of working hours on a private device? Yes. The very recent case of Edcon versus Cantamessa definitively deals with that. Yeah, effectively you must be reasonably connected to the employer, and if it breaks down the relationship of trust and or negatively impacts the employer's business and or reputation, you're going to find yourself subject to disciplinary proceedings, potentially termination of employment being a sanction. So that's on the table there for sure. And in addition, you've got a situation where you could find yourself liable for damages. How is a court going to determine that? There, the factors there, self-explanatory really. But you can also, as a plaintiff, apply for an interdict, and a pre-publication interdict is controversial, flies in the face of freedom of expression. So courts are going to be reluctant to want to do that. You're going to have to really go far to get that satisfied. We're starting to see courts start to look at sort of, natural justice, apology. LaRue versus Day has started to explore that and the philosophy behind that. So interesting there on the remedies. That could be, an hour or 2 hour discussion all on its very own. So I think trying to look at some of the more contemporary issues, I know I'm we're probably all gagging for lunch, and I'm running somewhat short of time. So I'll try to sum up in the next couple minutes. But some of the key issues that are affecting freedom of expression on the internet now and today, scandalizing the courts. And we've seen that very recently. State versus Mamabolo, the Constitutional Court confirmed that it's set quite a high bar, really. So you got to play the ball and not the man. If I want to use a sports analogy there, you've got to attack the judgment, attack the reasoning of the judgment. Be critical. That's important for the proper maintenance of the rule of law. But you shouldn't attack the judicial office or the court or the integrity of the officer. That will then raise questions, and Professor DeVos at UCT has got an interesting article on that and gives us an example. So we should be allowed to criticize judicial decisions. In fact, as an academic, it's our job to do that. But we must do so in a reasoned and lawful fashion. And effectively, we don't want to be this sort of quaintly named scandalizing the court, be commenting on the integrity of the judicial office or the process, because that can damage the rule of law, which is fundamental to any society. So really, again, there we're weighing up freedom of expression with the public confidence in courts. Another one is incitement to cause violence. And I'm sure we've seen that recently, and we'll see it again more and more so. And we had the recently decided matter of the EFF versus Minister of Justice. Parts of the Righteous Assemblies Act were declared invalid and unconstitutional, and that they conflict with the right to free speech. But there's a reading in here. So we can still have incitement. It's not to say the whole act's getting thrown out, but the court wanted to read in the words until Parliament rectifies this, serious offense. That raises issues. What's a serious offense? Court tries to explain it, but it's not a closed list. And again, there's more to come here. It's a dynamic, evolving area. And I think that's a really interesting part to be writing on now is this incitement and what's going to be happening with that law. And then finally, we've got hate speech, which is the elephant in the room often. Again, a very recent case. And what a time to be alive when we can watch our Concord judgments and some of our best advocates go at it live on YouTube. This was a 7-hour judgment dealing with the promotion of equality and prevention of unfair discrimination at Papuda. And as the courts have said, we've chosen to limit freedom of expression, but we've done it with this act in a way that has been found to be unconstitutional. And that judgment's out there. At Kwelani's case, the SCA said, look, it's gone too far. The way this legislation is crafted, it needs to change. Effectively, if I want to summarize it, what we're looking at here is no person in the interim, depending, of course, what happens in the Concord, haven't seen that judgment yet. Hearings taken place a month or so ago. But you can't advocate hatred that's based on race, ethnicity, gender, religion, or sexual orientation. And instead of it being an or, bit of a technical legal debate there, instead of it being an or, it's an and that constitutes incitement to cause harm. So that and is very important there. So that was the outcome of that. Yeah, so interesting times to be a defamation and free speech lawyer at the moment, or e-commerce lawyer at this time. There's lots of dynamic decisions coming out. The law's evolving, the law's fluid. We've got recent cases involving high-level politicians, political parties, and yeah, it's an interesting space. I think my takeaway comments in closing are that traditional defamation applies online. There's no different set of rules. If you say something that potentially is going to infringe on someone's reputation, you can't just think you're going to get away with it, notwithstanding what we sometimes see, particularly on Twitter, which can be a vile space to be on at times. Damages generally are relatively low, a couple hundred, relatively speaking. I mean, sometimes you're seeing people ask for millions. That's just not going to happen. You're going to see generally up to about 500,000 to 800,000 Rand. That's the sort of ballpark that I'm seeing recently, right down to about 50,000. So that's the sort of space that courts have been electing to give awards for damages, because it's not really seen as a stick to hit someone. It's really compensation for someone's dignity rather than a tool to punish. That's the philosophy that underpins that. So look, we're not anonymous. There's significant tools, forensic tools that can find who we are, notwithstanding the use of VPN and other clever technologies. So engage thoughtfully, engage reasonably. Don't share defamatory material. I would also say don't engage if you're drunk, angry, or hungry, or a combination of all of those. If you're a WhatsApp or Facebook administrator, watch that group carefully. Make sure that you understand that you can be liable for things that are on there. And yeah, guard your reputation jealously. I think it's important, particularly as we evolve into this society where we're more and more online. So thanks so much. If you want to engage me more after this, I would love to. There's my email address there. And thanks again to Sizwe and the organizers. It's, as always, been really interesting and insightful. Thanks so much for inviting me.
Hi, Lee. Unfortunately, you're not going to get off the hook just yet. The comment from Interconsult 21 Global, Dr. Lee Swales, what does it say? Just a second. Dr. Lee Swales, online conduct reflects the style of its user and ought to be empowered if the line is crossed. Then we have a comment by Dr. Julie Nwabuze. A code of conduct, including a balancing of interests, is necessary. Then we also have a comment here by Advocate Nsaluba from the defense. Thank you, Lee, for this. Just on time education and responsible behavior on social media. How are we ensuring that general public is aware of these basic principles? Let me give you an opportunity to reply to those.
Sure, thanks for that. Yeah, so I think you hit the nail on the head. We do require some kind of code of conduct. I think the difficulty there is that because these principles are quite fluid and it will depend very much on the context, it's difficult to set out a rigid sort of guideline that will say, in this instance, this is the result. So, you know, it's difficult to have almost like a mathematical equation where we say A and B equals C. So although a guideline would be useful, it's sometimes difficult when you sit down and think, how would I actually go about drafting this? I think that said, what we could do is maybe take principles from the variety of recent cases, and we've got rich jurisprudence here, and try sort of articulate some guidelines that would, I think, be useful in sort of setting out what, you know, the bounds really, what are the bounds of freedom of expression? And I think that would certainly be useful. And then insofar as when it sort of crosses the line, absolutely. And that's why we've got defamation, to ensure that there is, you know, this line, and that we need to, at times, hold people to account, frankly. And there are certain times where you think that's just too far, and we need to ensure that we engage appropriately and reasonably and constructively and critically where we need to, but of course lawfully and reasonably where possible. And yeah, with the online, with the dismissal of employees, it's something that I'm seeing more and more. Unfortunately, I've been involved in a few matters involving that, WhatsApp groups and posts, derogatory posts online. And yeah, it is something that's becoming more and more prevalent for employers, sadly. So what I'm seeing is that what the reasonable employer ought to do. So my answer to that is employers should have a code of conduct for social media and RTC use, should build that into the employment contract, and should provide training for the employee so that they can be seen to have taken all reasonable steps, so that when the employee does post derogatory, racist, hateful, etc. Commentary, that's in clear violation of both a code of conduct and the employment contract, and that training is being provided so that, you know, there's reasonable grounds to discipline and dismiss if necessary. But it's a difficult space because you have to look at each case on its own merit. So that's why I think it's always difficult to set out sort of rigid guidelines, because I think each case needs to be analyzed on its own merits. But thanks for that.
Thank you, Dr. Swales. I'm just going to read the last comments. I think we're out of time. Dr. Jolie Nwabuze says, the South African 2017 F&B case, which resulted in the subsequent dismissal of employees as a result of defamation on WhatsApp, is illustrative. And then Dr. Nwabuze refers us to a paper in which she published in the Intellectual Property Law Journal 2019. Interconsult 21, thank you everybody. Thank you, Dr. Sizwe Snail. I have other meetings, but it was great communicating. Thank you, Dr. Swales. One from Dr. Nwabuze. I think, Dr. Swales, let's cap it at that.
Thanks.
think you got your time. I fought for it. I made sure people don't disappear. So let's reconvene at 2:15 for the last session. Thank you very much, everybody.